The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. It's 866-610-NEWS to call the show and talk to the experts. Attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. 866-610-6397. AT&T Wireless customer star 610. Once again, 866-610-6397.
And I'm Shay DuPont here with bankruptcy attorney Michelle Hanash. Happy to be doing the Home Mortgage Law Show again this week for you all. Remember, we also have our Facebook page where I post all of the articles that we read during the week to prepare for the show, some of which we discuss here on the show. But really, we read plenty more than that, and we think they might be of interest to you. So if you are interested in reading more on any of the articles that we've touched on today or more, you can go to the Facebook page for the Home Mortgage Law Show. That's simply look up Home Mortgage Law Show on Facebook, and you will be able to also share your thoughts on the show. We've got some nice comments going on right now on the Facebook page. We appreciate it very much when people take the time to comment. Also, remember the webpage. The website for Morris DuPont is homemortgagelaw.com. So if you're driving, you don't have to remember the number to remember to contact the law firm to set up your free consultation. It's just homemortgagelaw.com. And, of course, the 800 number, 800-974-2712. That's 800-974-2712 to set up your free consultation with a member of the firm in our Tampa, St. Petersburg, Dadeland, Doral, Aventura, Fort Lauderdale, Boca Raton, and West Palm Beach offices. And let's get back to talking to Michelle. We were talking earlier about a view from the bench and how the bankruptcy attorneys met with the bankruptcy judges this past week. Got some tips from them on making their cases go through smoothly. But let's transfer and let's talk more about debt settlement, Michelle, because that's some fun numbers. I always like to hear about some of the great settlements that your department was able to achieve on behalf of our clients. So do you have one or two stories you can share with us that we can ooh and ah over?
I do. I actually brought three,
Oh.
and I think each represents something different that's important to share with the listeners. The first was actually a lawsuit that was settled, not directly related to a credit card debt or a personal loan, but really in regards to a contract and a breach of contract alleged claim against our client.
Oh, interesting.
Yeah, so there's all types of debt that you might have there, not just stemming from the typical credit card debt we might talk about most often. In this case, our client was being sued for $129,000. And that's a large amount of money.
It certainly is. So that was on a breach of contract claim. He had entered into a contract somehow and had defaulted on the contract. It wasn't related to his property. It was maybe a business transaction or something. And so then he breached that contract. He stopped paying. And so the person sued him.
Exactly. And this was obviously a big source of stress and a large amount of money. It's hard to think about for most people where you would come up with that kind of money in order to make this lawsuit go away. So we actually were able to settle the lawsuit for $35,000, which was a great result, a 27% settlement on that balance for our client. And he was very happy with that outcome. You know, the minimum we initially thought we'd be settling for when we went into this was around $50,000. So the fact that we were able to get it down to something that he could break up into several payments, and in exchange for this $129,000 lawsuit being settled.
You know, this is a very interesting case because it makes me think about my prior life in a big law firm in downtown, where a case like that, it would probably take the previous firm I worked at, it would probably take us about 18 months to settle that case, and we might come out with the same outcome.
Right.
But in the interim, we would have gotten about maybe about $12,000 to $18,000 in legal fees.
Right.
So give me an idea of, of the percentage that he settled for, or the percentage of what he owed, what your department actually charged in legal fees, and how long it took you to get this settlement for this person.
This settlement was achieved in, I'd say, 1 to 2 months.
Okay.
What we had to do, we actually had the litigation team involved for strategic purposes. There was, unfortunately, this client allowed a default judgment to be entered against him.
Oh.
He didn't have proper representation, and in fact, I don't think he had proper notice of the lawsuit, and that's why he didn't have proper representation. So we needed the litigation team involved to try and fix that issue that had arisen, that default judgment, because you're in a much weaker positioning power to settle when you have a judgment already against you.
Absolutely.
And
you have to get a motion to vacate
exactly.
the default judgment done. You have to win that, so you vacate the default, and then you have a response that includes either a motion to dismiss or affirmative defenses, so that you are now on equal footing or in a power position to begin the negotiations, because you don't want to negotiate from a weak point. You want to negotiate from a position of strength, showing, look, if you want to tangle, I'm going to be there and be ready to tangle. But if you want to settle, let's get this thing done now.
Exactly. And in fact, the other side was pushing forward with discovery. They wanted his financial information, bank accounts, all of this.
And ching, 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 for a law firm that wants to stretch it out and make a lot of money, that's where a law firm can charge a lot of legal fees in the discovery phase, because it's very labor intensive to review discovery and to respond to discovery. So that, for a law firm that really is looking to churn out some fees, they're thinking, great, let's not settle till we get through the discovery phase, because that's where we're going to make a lot of money in fees.
Exactly. And in fact, on the eve of these hearings that were set for our motion to vacate and on opposing counsel's request for discovery, their hearing maybe to compel answers to all this discovery they wanted, we were able to reach a settlement.
Beautiful.
Save the client money from going to the hearing, first of all.
Yep.
And engaging in this ongoing litigation and settle the lawsuit right there.
Beautiful result. Beautiful.
John, welcome to the show.
Hi, John.
Hi, how are you?
Good. What can we do for you today?
Good. My question is, I've been considering, my credit cards are really, really loaded, and I've been considering bankruptcy. But I do, besides my homestead property that has a $75,000 home equity loaded up, I do have a rental property which has great collateral. Now, can that stay away from the bankruptcy?
Well, my first question is the rental property. What's the current market value?
I would say close to 200, and I owe 70,000.
Okay, so you have about $130,000 of equity there.
Right.
So a rental property is not a protected asset when we talk in terms of a bankruptcy. Your homestead is. So the $75,000 that you have in equity in your homestead, generally speaking, is 100% protected in your bankruptcy from the trustee and your creditors. We have to take a break. So when we come back from the break, I'll go into explaining what that means for your investment property.
Okay.
All right, you're listening to the Home Mortgage Law Show, 1-800-974-2712. During the break, pick up the phone and book your free consultation, 1-800-974-2712. Ernie, you're next here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. 866-610-NEWS. That's the number to call here on the show and talk to the experts. Attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney. We're on the phone with John. Ernie, you're next. John?
And we've got John on the phone. Michelle, you were just beginning to answer John's question regarding his ability to qualify for a bankruptcy. We haven't even discussed which bankruptcy yet,
Right.
but the fact that he has $75,000 in equity in his home really isn't relevant because the homestead is protected, so that equity would be protected in a bankruptcy. But he's got a rental property that he has $130,000 of equity in. So Michelle, our bankruptcy attorney, was about to address that issue.
rental property, investment property in a bankruptcy is a non-protected asset, meaning it's just considered a regular asset, and the law protects for you in comparison to 130,000, not that full, not anywhere near that amount of equity in just a regular asset. So basically, this $130,000 of equity that you have in the property in a Chapter 7, you would have to pay back to the trustee to keep that property or give up the property. In a Chapter 13, you'd have up to 5 years to pay back that $130,000.
Are you there?
Yes.
We're here.
Okay, great. I just wanted to make sure. I was told that if I sold the property, I was still liable for one year of the money from the sale of the property in case I was to file bankruptcy.
The old clawback.
Generally speaking, a trustee can avoid a transfer within the last 2 years. So the trustee could actually go and undo whatever that sale was if it was a transfer. Now, if you sold the property as you needed to and you received fair market value and you received $130,000 once the mortgage was paid off, the question becomes, what did you do with that $130,000? That $130,000 in your bank is still an asset. It's still sitting there, and you would still have the same issue, whether it's a diamond, whether it's an investment property, whether it's a extremely fancy car, whether it's cash in your bank. It's in the category of a non-protected asset. So you would have the same issue.
So the issue there that his friend was trying to discuss with him is if you take that if you sell the property and take that $130,000 and put it under the mattress and don't declare it to a trustee, then and the trustee finds out about it, you are in huge trouble.
Huge trouble. And it's not a question of if the trustee will find out about it. The trustee will absolutely find out about it without a question.
Right. Okay.
So you have other issues. You've got some amount of debt that you want to deal with. What about debt settlement? What about instead of going through bankruptcy because of this rental property that you have that has $130,000 in equity, why don't we instead discuss in a consultation how we can otherwise deal with whatever debt it is that you're concerned about that you think that bankruptcy would solve?
So in other words, debt settlement will be probably the best case for me?
It might be,
Right.
but we won't know. That's one of the reasons that we offer the consultations free, because for listeners that are trying to say, well, gee, that kind of applies to me, and gee, what Shay and Michelle were talking about last week kind of applies to me. Don't try and do that. Schedule a free consultation. We'll sit down with you. We will look at your individual case, and we will discuss with you what we believe your particular options are regarding your particular situation and let you know this is an option, this is an option, this is an option, and then you make a decision what you think would be the best route to go for you and your family.
And you know, we always put it in.
Now that you brought that up, I'm loaded with the payments from my credit cards, but I have never been late. That's one of the things that I've always, loaded with it. Debt settlement, wouldn't that destroy my credit though?
Well, we were just talking about bankruptcy 5 seconds ago. So any loss mitigation option is going to have an impact on your credit score. And for me, that's the least compelling reason to decide what you need to do. We need to decide what path is right for you based on the outcome, based on whether it's going to get you back on path and take care of your problems. Either way, whether it's bankruptcy, whether it's debt settlement, there could be a negative impact to your credit rating, but that's something that fixes itself over time, and you can do credit restoration to fix it. You can take affirmative steps to try and correct the damage done, but you have to address your problems.
But Michelle, with debt settlement, it usually only takes about 90 days to settle a debt. So you default on a debt, 90 days later you've settled it. When you settle a debt, you are released of your obligation to pay it. Therefore, your credit score has the ability to go back up again. So if all you've done is go 90 days past due, you settle it, so the lender is reporting 3 months past due, and they're then reporting settled for less than full amount, you're talking about what? For each credit card, maybe a 50 to 75 point hit, and at most a cumulative effect, no matter how many credit cards that you settle, you're talking about a cumulative effect of maybe 170 points, and it's immediately going to start repairing itself after you have been released of the obligation to pay the debt, i.e., you settle the debt. So maybe 18 to 24 months to actually get your credit score back up to where it was. I'm sorry, I don't think that's a big deal, considering you might be releasing yourself of $100,000 in debt.
It's exactly right.
But the question, because I was listening to your program, and that. What about the high-low, the
HELOC, the home equity line of credit?
Would be able to be included in there? No.
We can certainly settle an unsecured home equity line of credit. So I think we've got a lot of options for you, John. And because if it's an unsecured HELOC, we can either get it forgiven completely or we can settle it out typically for 10 to 15 cents on the dollar. The earlier caller had a completely secured home equity line of credit, and he managed to settle it out for 35 cents or 30 cents on the dollar.
How do you know when it's a secured or an unsecured equity line?
You look at the value of the first mortgage, and you look at the current market value of the property. In the example I used earlier, it was $400,000 of mortgages on the property. First mortgage was $250,000. Second mortgage, or HELOC, was $150,000. If the value of that property today is under $250,000, that means that the second mortgage is now completely unsecured. There's no equity in the property for that second mortgage to go after. Think about it, John. If that second mortgage if you were to default on a second mortgage in that scenario, what would that second mortgage holder have the right to do? Well, certainly they can file a foreclosure action, but what would they get from a sale of the property? The property would sell for less than $250,000, so the first mortgage holder would get all of the money from the foreclosure sale, and the second mortgage holder would get zero, nada, zilch, meaning they are completely unsecured. There's no equity in the property for them to attach to. That's how you determine if your HELOC is unsecured. And by the way, in a settlement of a HELOC, if the HELOC is secured, you can settle it for that amount. I've got 2 minutes left. I'll give you this example. In the example I just used, let's say the value of the property, instead of being $250,000, is $280,000. That would mean that the second mortgage, that $150,000 mortgage, has $30,000 of equity in the property, right?
Right.
Therefore, you could settle that HELOC for $30,000, their equity position in the property.
Okay. Real quick, do you have a Miami office?
Of course, I have several Miami offices. I have Dadeland, I have Doral, and I have Aventura. So you're welcome to come in and schedule an appointment in in all three of those offices. But we'd love to meet with you personally. So make your consultation at the Doral office, and you can meet with Michelle, and you can meet with me, Shay DuPont, and we'll be happy to go through your options for you. So let me give you the number again. It's 800-974-2712. That's 800-974-2712. Come meet the ladies who can solve all your problems for you, John.
I will.
All right. Thanks for listening to the show.
You guys are great. Okay?
Thank you. Appreciate it.
I've been listening to your program for years. I want you to know that.
And this is the first time you've called us?
Yeah. Well, I just had the guts to do it today.
Well, thanks for calling. We really appreciate it. We look forward to seeing you real soon.
Take care.
All right.
You're listening to the Home Mortgage Law Show. Ernie, don't go anywhere. We're coming right to you after the break. 1-800-974-2712. That's the toll-free number to book your consultation at the law offices of Morris DuPont. 1-800-974-2712. 1-800-974-2712. Much more of the Home Mortgage Law Show and Ernie right after this. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. 866-610-6397. That is the number to call and talk to the experts right here on the show. It's attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney, and we're taking calls 866-610-NEWS, 866-610-6397, AT&T Wireless customers, star 610.
And we're going to be going to the phones.
Ernie.
Hi, Ernie.
Good afternoon, ladies. How are we doing today?
Well, good afternoon to you. We're doing fine. What can we do for you?
Good. Shay, first I wanted to thank you for your time about, a month ago, I guess, we spoke very briefly about my situation. And since then, things have evolved somewhat. And toward that evolution, I wanted to say that listening to your show has proven invaluable with respect to education and what to do, court process, and such, a number of areas. So thanks. It's
You're
good.
very kind, Ernie. Thank you for saying that. You made my day.
Well, it's the truth, truly. I mean, it is.
Thank you.
Well, if I can do a quick recap and then kind of bring you up to date on where things are at the moment.
Sure.
So last go around, just briefly, I was renting a house from a gentleman. The house was in foreclosure, unbeknownst to me at the time of signing the lease. The gentleman passed away here about 2 months ago.
Oh, sure. I remember this. Yeah, go on now. I remember this story. Yep.
Yes.
Yeah.
And after some good detective work, I must say on my end, I was able to finally track down the executor and to get them involved in the process too. But just briefly, the attorney that was representing the owner filed a motion to withdraw from the case. The judge granted that at a hearing.
Not being paid.
Right. So that was back on October 23rd. I attended that hearing, and it was kind of odd. I must confess that neither of the attorneys there, plaintiff or defendant, had identified the trustee, or the executor rather, and which I was able to find. So I mentioned that to the judge. And he was none too happy, let me tell you. But nonetheless, that's it. What's happened since then, Shay, is that we've had that original owner's attorney withdraw. We have now a new group that has joined in the fray, a leasing company, which I am just a little uncertain about as far as their relationship to all this and the ownership of the house.
A leasing company?
A leasing company, yes.
Oh, boy.
And so they have, they've joined the fray, and they have retained a law firm out of Kendallwood, down Miami.
Sure.
Okay? So we have that. We have the bank originally, that I thought was just the single owner, but apparently that's not the case. The realtor that leased the home also is involved, as well as the Homeowners Association attorney now.
Oy. What a rat's nest this thing is turning into. And there you are, trying to figure out who to pay.
Well, I tried that, Shay. I did it in my best effort, and I was
did.
able to speak with the executor, and I said, look, I've got your rent money. Who can I give it to? And I was told that they were unable to accept it. And that was that. So I sent an email to them, and I said, okay, this is to recap our conversation. You're saying that you can't accept it, and please reply. And they did. So I have that annotated at least in
You're covered.
the email.
You're covered. It's not like you didn't try to pay somebody while you're renting that house, but there's nobody that it can accept a payment at this point. So how long has it been since you made a lease payment?
Just 1 month.
Okay.
Just 1 month. Okay, just missed it. So we've got now a notice that we received from the court here in Pinellas County, and scheduling a case management conference for the about the third week of January or so. And that case management conference in that document that was sent to me. By the way, the judge was kind enough to put me on the service list,
Great.
which was just about impossible to get on, without bending over backwards to some of the attorneys. But nonetheless, I got on the service
That just
list.
requires a letter to either of the attorneys, and they would be, or the clerk of court, and you would have been put on the service list. So it's not that hard. But go on.
We'll see that. Well, now I've learned something new already.
Yep.
So now I know. So at any rate, so there's a case management conference coming up, and I read through the paper. This, as I understand, the case management conference is an order referral to a magistrate.
Yep.
Okay. And the magistrate is going to be the one presiding over this. And in the bulleted list of items that are cited that may be discussed during this meeting is. They go through a long list of issues and matters, but the one that sticks out to me is the motion for summary judgment, that might be presented, at that get together, if you will. So, I guess my question to you is, given that I know it's a brief background, but with all the attorneys and all the companies involved, the leasing company, the bank, and so forth, the realtor perhaps, because, and trust me, I don't know why, but they are. Maybe it's the fact that the realtor leased the property to me without notifying me that it was in foreclosure, at the time that happened. The house had already been in foreclosure.
I know that question's coming, Ernie. I know it's coming. Come on, Ernie.
Sorry. Okay. So, okay. What do I do, Shay? What do I prep for this case management conference? What's the best strategy here, and should I retain an attorney?
It depends on what your goals are, Ernie. It depends on what your goals are in relationship to this house, because if they get let's say that everyone agrees at the case management conference that a motion for summary will be granted. They're not going. Let's say that that the estate is not going to fight the foreclosure. That they would just rather turn the property over to the bank and sign off on a consent judgment. They'd have to find who would be authorized to sign off on that, and they would consent to the foreclosure going forward because there's no equity in the property. The deceased owed more than the property is worth. Why would a estate then fight the foreclosure? They would just go ahead and allow that motion for summary judgment to go forward, get a sale date set, and voila, the house would change hands. Now, if the person who buys the house at the foreclosure sale is an investor that would be interested in having you stay there, then you could sign a new lease with the investor that purchases the property. But of course, you're rolling the dice that an investor is going to buy that property at the foreclosure sale. If it's someone who will want to be in that property as their primary residence or does not want to lease it to you as an investor, then you're probably going to be out of the house within about 30 days of the foreclosure sale being completed, 10 days for the transfer of the title, and then 20 days for them to actually evict you from the property. So you still are going to have a lot of time, at least until January, because the case management conference is until January, then probably another 60 to 120 days for a foreclosure sale. So you're probably going to be able to stay in that property very close to the end of your actual lease expiration date. But how much further you're going to be able to stay in there, you're not going to know until a couple more decision branches come to fruition. Will the motion for summary judgment be granted at the case management conference? Is there going to be some defenses raised to the foreclosure action, or is whoever is in a position of authority going to just consent to the foreclosure going forward? These things have not yet revealed themselves to you, so you're really kind of in a state of limbo until further information is provided. But certainly I suggest that you continue to stay involved. You do attend the case management conference. You do have a financial stake in this property vis-a-vis your lease. So you do have a right to attend these conferences and to speak and represent your interests. So, you've got still some chances to be able to move forward and be in possession of this property for a longer amount of time. Does that answer your question?
I believe it did. Now, one final one then. So with all this, I know I don't really have a dog in this fight, so to speak.
You do.
But well, okay, it's a small dog. It's not a big one.
Yes, little Chihuahua barking.
That's right. Well, thank you. But nonetheless, you got me on that one, Shay. With that Chihuahua, though, should I? Would it be good to have a Chihuahua representative to help me through this process, or
No,
what?
darling, it's always good to have a pit bull representing you.
Okay, all right.
If you're going to go
You
for it, go for it, right?
okay. Yeah, right. I mean, why not? So,
But
you have
the
a
question would be, what are you really fighting for? So this is what I recommend,
right.
because I got to get back to Michelle. She's really wants to be able to also explain some of the great things that she was able to do for her clients, and we only have 15 minutes late. So Ernie, you've called me at the office before. Call me again. You know I'm happy to talk to you, and we can speak for a few minutes, and I can give you some strategy pointers. Give me a call, 800-974-2712, and I'm happy to talk to you, and we can discuss this in more detail.
Very good, Shay. Thank you very much for your time. I greatly appreciate it.
You're very welcome, Ernie. It was a pleasure to speak with you again. I'm going to try and help you out with this.
You're listening to the Home Mortgage Law Show, 1-800-974-2712. 1-800-974-2712. Nothing but pit bulls there. The Home Mortgage Law Show. Plenty more coming up right after this. And we are in the home stretch of the Home Mortgage Law Show. If you've got a question or comment, now's the time to pick up the phone and talk to the experts. We have attorneys Shay DuPont and Michelle Hanash, our bankruptcy attorney, in the house. We're here till 4 o'clock, 2 to 4 every Saturday. 866-610-NEWS. That's 866-610-6397. AT&T Wireless customer star 610. I think you want to hear that number one more time. 866-610-6397.
I don't know, Natalie, because really I want to hear from Michelle. So, yes, I'm happy to take some calls, but I wouldn't be surprised if we take up the next 10 minutes with hearing some of more Michelle's success stories. But before we get to it, I do want to remind people I was in the Tampa office last week. You know, I normally work out of the Miami office. We've got JC up in the Boca Raton and the West Palm Beach office, and the rest of us just kind of go around between Dadeland, Aventura, Plantation, Fort Lauderdale. But I am going to be back in the St. Petersburg and the Tampa office next week. So if you are interested in booking a free consultation with me, Shay DuPont, you're welcome to call the office now. We do have people in the office that can schedule your appointment. The phone number to call is 800-974-2712. That's 800-974-2712, and you can always call to also book your bankruptcy consultation. I wanted to get back to Michelle Hanash, our bankruptcy counsel here on the East Coast, and talk a little bit more about some of her success stories in this past week. Michelle, I thought it was really interesting that you had done a settlement on a breach of contract case, and to remind people that it's not just credit card debt that we can settle, and it doesn't have to get to the point of a lawsuit. If you've breached a contract and you do want to propose a settlement, I strongly do urge you to do it through an attorney. You're probably going to get much better results. It's really saving money by actually hiring an attorney, as that might seem to be contrary to common sense, but once you hear us out, you'll understand why. How about another success story?
Well, sure. And this is in the form of another lawsuit, but this time a credit card lawsuit.
Mm-hmm.
And, you know, sometimes the clients are just not prepared. It's not necessarily that they waited too long to come to see us, but for whatever reason, one of the few times, I would say percentage-wise, the lender goes ahead with litigation on the account, because obviously the vast majority who have defaulted, who are unable to pay their credit cards, don't wind up in litigation, or else I don't even know how many more lawsuits we'd have clogging up the system.
Sure.
There's just a very large amount of people who are unable to pay their credit card debt. In this case, the lawsuit was filed and the account balance was $24,914. So another rather large credit card account. And
Sure.
this client actually was dealing with quite serious financial hardship in the form of ill family members that he had been caring for, and underwater property that he couldn't get out of, that he was forced to keep making the payments on. Instead of selling it when he knew he couldn't afford it in his budget any longer, he drained all his savings and finances trying to actually pay down the debt. And then finally, there was just not enough money or income there to keep making payments. So in his case, we were able to settle his account for $12,000 in multiple payments. So that's actually a 50% settlement, which when we deal with settling credit card debt in litigation is the average. You have to remember that once a lender goes and takes the effort to hire an attorney to sue you, they've incurred some additional costs. They've put some time and effort into it. For whatever reason, they're under the impression that you have something they can collect against, that you're one of the few that it was worth suing. And sometimes they can be completely wrong on that assumption. But nevertheless, we find that when we're settling lawsuits, we're settling for a bit higher of a percentage. On average, 50%. That doesn't mean we can't get a lower settlement.
Okay, I have some questions about this. It's a great settlement. I mean, 50% when there's litigation involved, I like it. But I have a question more about credit card litigation. Isn't it true that there have been studies done that when these credit card companies do institute a lawsuit against a borrower on a credit card debt, that it turns out that there is a very high percentage of litigation that has improper documentation, and so actually there's a very nice likelihood, a good percentage, that you can actually get dismissed. So when you do these kinds of settlements, has the litigation department at Morris DuPont been aggressively defending the lawsuit and also looking at the paperwork that the credit card company submitted with the complaint?
Right. So we actually do have a client currently that we're working on getting their credit card litigation dismissed because, in fact, the lender named the wrong account number in the complaint. I mean, just obvious mistakes, not the right documents attached. It all depends when you look at your complaint, what documents have been attached and what it states. And if your credit card statement is there and it's correct and the proper documents have been there, the likelihood of getting the lawsuit dismissed is not great. And
I understand that if it's all correct, but that there's actually a professional within the office that is reviewing these documents to make sure that they have hit all of the statutory requirements. So even if they have attached what look like proper documents, there might be requirements that the court has that an individual borrower wouldn't even be aware of. And I just want the listeners to understand that if you have had some lawsuit initiated against you by a credit card company, you want an attorney to review the documents that are attached that are attesting to and are proof that that credit card amount is due, because very often it has been found those documents are incorrect.
And that's very important. And you're only going to get that type of attention if you're going to see an attorney, if you're asking an attorney to review these documents instead of going to, as we spoke of even with loan modifications, a non-attorney type of business that is just, a high volume type practice that isn't paying specific attention to your case.
And I have another question about the case that you just talked about with the settling a $25,000 debt, and his home is underwater and he's got family members that have had illnesses that he's paid some amount on. Was there a screening? I mean, did you talk about bankruptcy and why did he decide against bankruptcy?
Absolutely. We talk about bankruptcy almost, the majority of the time when someone comes in to talk with me, we don't know which way we're going to go. In his specific case, he had a business that he was worried about and needs perhaps to make sure that business is protected and outside of the bankruptcy realm. So it can get a little complicated.
Also,
issues
credit
like
scores. Credit scores can be greatly affected by, and if you need your credit score for your line of credit and you need the line of credit for your business, that's something that certainly.
Exactly. And, it really depends on that specific person. Sometimes debt settlement makes more sense than bankruptcy. Sometimes you can gather those funds, you have them to make a settlement in the range of maybe 35%, if it's litigation, maybe 50%. So you have some cash that you can make settlements with, and it makes more sense than filing a bankruptcy.
Well, and also, you have to balance out how much debt you've got versus settling it versus what bankruptcy can do, because, I know $10,000 to $15,000 is a lot of money and it's a lot of debt for someone to carry. But often when I'm doing a consultation and I talk to people about the amount of debt that they're carrying, and it is that amount, in my mind's eye, I'm thinking, well, I'd rather settle that out for 10 to 15 cents on the dollar or, if it's an unsecured note, or if it's a credit card, settling it out for 35 cents on the dollar, than to think about bankruptcy for them. And why? Because when you file a bankruptcy, great, you then have gone through the whole process, you get a discharge, but you are then not allowed to file bankruptcy again for 10 years. So
I have to correct you.
7 to 10? 7 to 10?
It's depending on the type of chapter you're filing and what you had previously filed. It could be anywhere from 8 years from filing to filing chapter 7 to chapter 7 down to 4, between a 13 and a 7. So it really depends on the chapter that you're going from and to, but 8 years between 7s is probably what we're thinking.
All right, so that's 8 years of liability exposure in my mind as a litigator, because if you file bankruptcy and then, God forbid, a year later an accident happens on your property and you're sued and someone gets a judgment against you for $250,000, guess what? You can't file bankruptcy because you just filed bankruptcy a year earlier to get rid of $10,000 worth of debt, and now you've got this exposure to liability and judgments that you have no protection on.
Well, you want to make sure it's the right time to file, and that's also why some people's credit score increases after they file for bankruptcy.
Well, it's always a pleasure to have you on, Michelle Hanash, our bankruptcy attorney. Next time?
That's it. Next time we'll have plenty more. You're listening to the Home Mortgage Law Show, 1-800-974-2712, the free number to book your free consultation at the law firm of Morris DuPont. The Home Mortgage Law Show will see you next Saturday.